to be very interesting. Our next session is more about the practical problems or practical issues of intellectual property rights. Therefore, we invited Mr. Knut. Professor Blind is head of the economic of innovation department at the Technical University of Berlin and professor of standardization at the Department of Management and Technology at the Rotterdam School of Management at the Erasmus University Rotterdam. Since 2010, he chaired in addition the Public Innovation Research Group at the Fraunhofer Institute for Open Communication Systems. Besides intellectual property rights and piracy of products, his research includes market regulation and innovation, standardization and technological change. He has broadly written about patent policy, intellectual property protection, industry standardization and the impact of regulation on innovation. His recent work, and therefore I learned about him on the economic account of intellectual property protection, focusing on small and medium-sized business, I think is pivotal for the discussion in our next session.
Ladies and gentlemen, dear Mr. Hendricks, thanks for the invitation, thanks for the nice lunch, and also thanks for being a speaker here among all the distinguished previous speakers. I'm really honored to be here. And I think what I'm going to present is really complementary to the more theoretical but also more anecdotal discussion we had in the morning, because I'm going to talk a little about product piracy and counterfeiting, trying to put a little bit more light on the empirics behind this rather difficult topic. And I draw here on findings we have found in a study for the German Ministry of Economic and Technology, published last year. The issue is that, and I think the previous speakers have also shown this, that intellectual property is increasing in importance. We have growing applications in different patent offices, especially in Germany in the 90s. But what we see now, and this country is not included, that especially the new countries like China are catching up. For example, in China, the number of patent applications in the last year was around 250, 300,000. This is quite a lot. Whereas we see in the US, but also in Europe, some kind of stagnation, also a little bit due to the economic crisis. And especially if you are looking who are the drivers of the patent kind of expansion, these are mostly very large companies, multinationals. They have really increased this activity a lot especially in the 90s, but also after the recession, after the dot-com crisis. Again, this was driven by the multinationals. On the other hand, we see only a rather moderate increase in research activity, and the question is, that means we have on the one hand very strong activities in patenting, on the other hand the input the companies are investing in research is not growing so strongly. For example, the European Commission had published the so-called 3% goal in the year 2000. The objective was to reach 3% spending on R&D of the gross domestic product in the year 2010. The European Union as such failed, and Germany tried to reach the 3% goal. They ended up with 2.7, 2.8% of the GDP, and only Sweden and Finland made it with 3.544% of the GDP investing in R&D. This is the kind of the input side. But on the other output side, the question is why we see such a strong increase in patent activities with growth rates of 5, maybe even 10% in some years. And we did a study 5 years ago for the German Ministry of Education and Research, and there we were looking at the strategic motives to patent. And we found out that besides the original intention to kind of give a patent as a gift for protecting intellectual property, there are other reasons why companies now use patents for different purposes. On the one hand, companies are using patents to block competitors, which was certainly not in the intention of those who set up the patent system. That means this is also a critical point. A more positive issue is that you are also now filing patents in order to trade technology. You all know open innovation as a new paradigm, which is more or less substituting the closed innovation paradigm. And if you have open innovation, then you have to also licensing in technology which you are not able to do yourself, to develop yourself, but you are licensing out technologies which you might not using for putting together your final products. And therefore patents help to facilitate this exchange, because otherwise you cannot really transact technology if there is no right on the technology. This is another point. A fourth point is that patents are also used to improve the image of the company. We have looked at the annual reports of companies, and it turned out that in the 90s there you almost find no indication of how many patents a company has filed per year. But now, since the last 5-10 years, companies are very proud if they say, okay, we have increase the number of our patent filings by 10 or 20%. This is an image issue. And finally, patents are also used to manage R&D activities within a company. For example, big players like Philips and others, they set at the beginning of the year some objectives regarding the number of patents they'd like to have at the end of the year. And depending whether these objectives have been achieved or not, the decision about the future R&D portfolio is made. And that means patents are also an instrument to decide about the R&D budget. And finally, it's also an instrument to maybe to put incentives on the individual R&D worker to say, okay, if you are very good in patenting, you might get a bonus or something else. That means there are some other reasons why we see this increase. Next point, it's not so easy to talk about piracy, counterfeiting, because in general, those which are victims of product pirates are very sensitive, and they are also very general if they talk about product pirates, because they do not really consider that infringement in the narrow sense is only kind of taking place if we have properly defined property rights. And if you have a competitor which is kind of quite good and which is going to imitate your technology, and these technologies are not protected by your by some kind of rights, then you are not talking about IPR infringement. And we are currently trying to publish an article, and we have a very lengthy discussion with the editor. What is IPR infringement, what is piracy, and what's just imitation. And meanwhile we found a definition, but it's really not so easy. And this is relevant because in this study we did for the German ministry, we found that around 40% of counterfeiting or imitation cases, here there are not really rights which have been violated. And therefore this is not really illegal in the narrow sense. This is one problem. Another problem in studying this phenomena is that it's really difficult to quantify these losses by IPR infringements. The OECD started to do that around 10 years ago. You will see shortly some figures. And they come up with a rather general methodology to make some assessment. And this is also the case because what are the damages? One damage is if the product pirate sells a copy to one of your potential customers, then you have maybe a reduction in sales or turnover. But as we have heard in the morning session, there are also other damages, like if the product pirate sells some drugs to people, and these drugs are not working at all, or maybe are poisoned, and therefore the harm is a different way, and then you have maybe kind of damages of images, where the company image is ruined. And for example, in Germany there's a company which is producing saws for cutting wood, Stihl, very kind of proactive guy in fighting against product pirates, and there are some accidents happened because product pirates copied these machines, and then the technology was not the same, the quality was not the same, and then the workers were hurt. That means this was then a negative feedback for the company and the brand, and therefore there are different types of negative implications, and therefore we used different approaches to try to get a little bit better idea what are really the losses. And we are doing further work now within companies because they have opened up their internal data also, especially in cases where they're involved in China, and now we are continuing that, but this is not yet published. What are the images, the damages in general? Here's an overview. As I said, the OECD started to do that, and they did that in a way that they just kind of tried to say, okay, around 5 to 7% of the world trade volume. That means they were just looking on the cross-border trade and made some assessments based on some poll statistic that around 5% of the world trade volume is affected by piracy and counterfeiting, and then they come up with 350 billion US dollar. 10 years later they recalculated this, and then they had to adjust a little bit the figures down to 200 billion. A recent study kind of
so
also...
Quick question.
Yeah.
How much, so kind of with the inflation, how much would percentage-wise would be 200 billion compared to 350 billion?
A very recent update of the OECD, where they adjusted the methodology, they say it's around 2%. The 2% of world trade without digital piracy. That means what Stan talked about was excluded. Then there are other kind of industry-specific studies by the Business Software Alliance, with 28 billion in the case of software piracy, and the German Association for the Machinery Industry, BDMA, they are doing this in a regular case, and they came to the figures that around 2/3 of their members are affected by counterfeiting, and 80% of them had losses more than 10% of turnover. In total, they say it's around 7 billion euros per year. Then the German Chamber of Commerce did a similar study just focusing on China, where they come up with 30 billions or 70,000 jobs for Germany which are lost. That means very different figures. Currently the European Commission is conducting a so-called piracy observatory study, which is conducted by RAND. I have seen kind of first ideas how they try to do it. I'm not sure whether they will come up with more precise figures. That is really difficult to do that. What we did then is we surveyed all companies which were active in patenting or which were active in R&D. And what we found in our study is that around, like the machinery sector, 2/3 of the companies were at least rarely affected by patent or trademark infringement. And if you're looking here down, this is in the case of patents 60%, but in case of brains a little bit lower, who are affected. And we are also differentiating by company size. Here are more than 500 employees, and here are the very small companies. And you see in general, the larger the company, the higher the likelihood that you are affected. But this is a rather trivial result. And this is also due to the case that large companies are kind of active outside Germany, outside Europe, and therefore the likelihood of getting infringed and violated is a little bit higher. But now, what we did in a parallel study in cooperation with the Center for European Research in Mannheim, they did a large-scale study where 30,000 companies were approached via a survey and 6,000 answered, and therefore these figures are really representative for also for the industries. And you find different results. There's just a differentiation between small and large companies, and you see in all cases large companies are much more often affected. And the question was, has intellectual property of the company been violated by other companies in these years 2005 to 2007? And you see here the large companies in general are affected 50%. That means every second company is affected. The small ones only 10 to 20%. But what we see that especially in the high-tech sector, mechanical engineering, electrical engineering, medical technologies, here the numbers are higher, and you are then above 20%. In the low-tech sectors like furniture, textile, nutrition, timber and paper, this is less than 10%. Okay, and in chemistry also both small and large companies are affected. This is kind of one major result. That means there are strong differences between sectors, and high-tech industry is much more affected. And an even more differentiated picture I'm able to give here, because we were asking different types of infringements or violations. And here you see different aspects. First, we have here the differentiation between small and large companies, and we are just focusing on the innovating companies, but this is the majority of the companies surveyed. It's around 80% of the German companies claim to be innovative. If that's really the case, that's not a question, but nevertheless, this is a rather large number. And you see, for example, again, the small companies are less affected. Here, technical invention, the textile industry is mostly affected. And if we are looking at the large companies, technical invention, that means this is patent infringement. In the narrow sense, mechanical engineering, 56% of the companies, medical technology, 52%, that means more than half of them are affected, whereas in the low-tech sector, furniture, 3%, here again, plastics and timber, textile, almost no problem. If we are looking at products and business models, it means the infringement of complete products or business models, because this survey is also covering the service sector, which is not here included because this is a little bit, it's not so relevant. We see here different pictures. In general, complete products are not so often copied by infringers. We find this only in medical technology with one-fourth of the large companies. Among the small ones, it's no issue. What is more likely is that product names, that means also brands, are counterfeited by pirates, and this is also a little bit the case among small companies, especially in the chemical sector, but especially if you're looking at the large companies, you find this also in the textile industry, where the brands are very important. Therefore, you have here higher numbers. You have quite significant numbers among the mechanical engineering, electrical engineering, and the medical technology. For example, when we are in close collaboration with Bosch Rexroth, this is a company, they are producing pumps and valves for high-tech kind of technologies, for example, for windcraft mills. They are producing the part where the rotor is connected to, and they showed us example of what happened, especially in China, where on the one hand very stupid copies can be found, where they talk about Bosch, Rexroth, where they just are not able to spell the names in the proper way. But what they now find recently is really perfect copies, where everything is really perfect, and they have really trouble to identify the difference. That means this has changed, and they are putting a lot of investment in going after these. I will talk a little bit about strategies to overcome this. And finally, because this was also a little bit addressed in the discussion, design. We find this in the electrical engineering sector in almost 30% of the cases, also medical technology, where kind of final kind of products and the design of these products has been copied by pirates. And as you see here, big difference again between small and large companies, but also between the different types of infringements and violations. That means this is not the same over all industries, although one has to see that especially mechanical, electrical and medical technology, the likelihood of being a victim of pirates is quite higher than in low-tech sectors. And the last point, which is important to mention. In general, if you are thinking about counterfeits and patent infringements, we are thinking about some companies which are not active or located in Germany or in Europe, but abroad. And but here are differences. For example, in inventions, the companies in the glass industry say that 20% of the pirates are domestic actors. That means mostly competitors, whereas abroad it's only 10%. That means here it's the other way around. In other sectors, mechanical engineering is 20-25%. Electrical engineering, you see here, it's more infringement and counterfeiting by domestic competitors than by competitors abroad. That means the argument we had before that it's not so easy to copy, can be shown here very, very well, because some of these products are so complex and so difficult to rebuild that it doesn't make sense for a company or in East Asia to rebuild that, because they just have not the capability to do so. And therefore it's much easier for the competitor which is located around the corner to do so. Yeah, because often they also exchange personnel, and then it's rather easy to say, okay, I hire you from the other company. Sure, there are some clauses in the contracts which may be not allowing to draw on his knowledge within a certain period, but after 1 year, in general, it's no problem. And then they are able to rebuild quite a lot of these products, and the so-called tacit knowledge is just transferred via hiring these people. Yeah? And this is much difficult for companies in East Asia, and therefore we see in some German universities, for example, especially when these universities are funded or in close contact with the German engineering industry, and they say, okay, we still sponsor you, but you are not going to hire some people from East Asia. No students, we do not want to see Chinese students in your university institute. Yeah, because there is certainly a likelihood that there might be some leakages. Okay, and what you see here, these are the technical inventions which are more likely to be kind of copied and infringed by domestic competitors. But if you're looking at the names, it's much easier to copy just the name all the way. Yeah? And therefore, you see the ratios are 2-to-1 or 3-to-1 from those infringers and counterfeiters which are active abroad compared to domestic counterfeiters. Because a competitor which is kind of located around the corner or within next kind of the same country, they are not going to replicate Bosch Rexroth or another brand. They only companies which are active maybe in India, China, or in other countries will do that. It means there's also a big differences. It means in general we have differences between industry channels, differences between the sectors, the types of IPRs, and between the location of the counterfeiters of product type being active either at home, that means in Germany, or abroad. And therefore it's not clear, it's not a clear-cut one-way picture. It's a very, very differentiated picture. And we are currently doing some research where we look at the strategies of companies, looking at the typology of Porter having cost differentiation versus or cost reduction versus differentiation strategy. And here again we see differences. Also, what kind of strategy a company follows and the likelihood of being infringed. Okay, now what is then the impact? Coming back to our figures, we asked them what is the loss in turnover and what are additional costs, and you see here we have around 12% of the companies which say we have a loss between 6 and 10% in turnover, and we have also around 10% of the companies which say we have additional 3 to 5% cost. That means in general the losses are rather low here. That means half of the companies say we have maximum a loss of 1 to 2% of turnover, which is not quite high. And most of them have also no additional cost, but as I said, 12% of the companies reported losses of more than 10%, and additional monetary expenditures range between 1 and 2% of turnover. It means if we take all together, we have around 6% losses related to the annual turnover. This is, if we kind of extrapolate that to the whole German economy, it's around 50 billion euros. Now, and this is an interesting picture, is what is the reaction? How do companies react to these kind of incidences of being a victim of product piracy? What are they doing? And this is just a qualitative assessment because it's rather difficult to make some quantitative assessment. This is the first reaction, is we just increase our informal protection methods. That means we try to make the products very complex that they cannot be opened, like in the Siemens case. That means they cannot really rebuild that. And you see no really big difference between the size classes. That means these are the 4 size classes. All companies say, okay, we are doing that. But more interesting is the second reaction, is we use more formal protection methods. That means we apply more patents and other IPRs. And you see here, definitely the larger the companies, the more they react in applying more patents, registering more trademarks, and doing more on the formal way. That means there's a discrepancy then between SMEs, small and medium-sized companies, and the large players. Another reaction is we increase the expenditures for the maintenance and the enforcement of our IPR. It means we are now sending our lawyers to China, or we're building up kind of a unit in China which is going after these pirates. And I know from Siemens and other big companies in Germany, they have set up in China and other countries such units. And they try to be effective in the way that they hire Chinese lawyers, and people who know the system, how to work it. But this is only affordable by the big players. The small companies cannot do that. That means here again a reaction mostly by the large players. And what we find here among the small companies, they say, okay, we break off some business relations, because we say we go back. We go back to Germany or to Europe. And if we are looking at the last option, we reduce our R&D. But this is not really a strategy that you see almost nobody is doing that. Yeah? That means the R&D reduction is not really a strategy which is taken by the companies, but more important is really that the big players are pushing this and are pushing more into R&D. That means the incomplete IPR system is triggering even more applications for patents, and is also a little bit discriminating the system, which is not so easy to tackle by the SMEs. That means here policy has a problem, because the whole IPR system is already driven by the big players, and due to product piracy, the patent system is even more pushed by the big players and not by the small companies. To come to a conclusion, we all know that IPR is becoming more important, and this is kind of new insight. But we see that there's a significant incidence of IPR infringement, especially patent infringement, but also trademark infringement. And we see here also big differences between industries and size classes. Yeah? And we also see, depending on the type of industry, we also see that different rights are infringed and violated. That means high-tech industries here more the technical rights in the narrow sense, means patents are infringed, whereas kind of in the consumer industry is more the design and the trademarks are infringed. That means here are differences. We also see rather a heterogeneous distribution of damages. Yeah, the majority is really not hardly affected. Yeah, this is kind of between 1 and 3% of the total turnover. But a few companies have really trouble that these damages are threatening their business. And we are currently doing a study on IPR infringement via distribution of goods via the internet. That means via eBay and other platforms. And here a new insight is, which is really surprising me, or I didn't know about that, that the very valuable brands are not so severely kind of affected by this, because they have found some arrangement with these platform providers that these copies, illegal copies and products provided by product pirates are not getting into platforms like eBay. That means this is also a new insight which is going to be investigated in other research we are doing. And this is more or less the most important insight. We see different reactions of companies depending on the intensity of damage. That means those, and I didn't show the figure here, those which have been affected by product pirates in a severely way, they really have a very specific strategy how to deal with that. And those which are not really significantly hit are really do not really taken care of these things. And we see that depending on the company size, we see different reactions. That means the bigger companies have the strategy to go for even a more intensive use of the IPR system. They also put much more money in enforcing their rights, but these resources are not available for small companies. That means the phenomena provides some new challenges for IPR, trade and SME policies. One has to reconsider how to deal with IPR in general. One has also to look how to tackle the problem that the majority of the illegal copies and the counterfeited products are coming from specific countries, and there the trade relations are a little bit kind of affected, and this is also an issue. For example, in the G8 summit was 2 or 3 years ago here in Germany, this was a hot topic between Europe, especially Germany and China. And also all these phenomena have some implications on SME policies, because SMEs are a little bit handicapped in using the IPR system, but these reactions triggered by big companies are even making SMEs more handicapped in using IPRs, especially patents. So, thanks for listening.
Thank you, Mr. Knut. Yeah, I will ask you for questions. I think we make a question and answer on about 20 minutes. So we are not too much stretching our schedule. Who wants to ask?
Yeah, thank you very much. It was very interesting that you have an effort to really look into this very deeply and try to find out on an empirical basis how big the problem is. I have several questions actually. One, your knowledge comes from surveys, so you don't know what's happening, you only know what people claim what's happening. That's one thing. Then the companies you're talking to, if you ask them about infringements, I assume that the same companies that complain about infringements infringe themselves. Because everybody is claiming the other is infringing. So is there a problem really, or do we just have an equal distribution? You have not talked about the economic gains of the infringement. There may be an economic gain of infringement. That's, I think, probably interesting. I'll leave it with that.
Okay. Yeah, indeed. First, it's just survey data. Although we are looking also on toll statistics, and for some European countries, the toll statistics is quite okay. For others, do not provide really good data. But at the end, kind of our assessment of the total damage is quite close to the other figures which have been calculated so far. And this survey approach is the critical point, but it's rather difficult to get access to other data. And kind of some colleagues they are looking at the pirates, trying to analyze the different types of product pirates coming from the other sides. And there are some consumer research going on where consumers are asked about their consuming behavior, whether they buy illegal copies with the intention to buy these cheap products or not. This is another way, but these are kind of complementary approaches to really to narrow down a little bit the range of the phenomena, but there's not a real kind of ideal way to define this phenomena. And this is a little bit the problem we had 10 years ago when we did our studies on software patenting, where all the open source guys claimed that they feel threatened by patents, but we couldn't really find big evidence. That means there's certainly an over claiming, and this is also a little bit a methodological challenge, and therefore there are not so many studies around. The other point where you say the one says, okay, I'm infringed by the others, but the others are also. And you see this a little bit here. If you're looking at the domestic phenomena of IPR infringement or patent infringement, the closer the competition, and we find that also in other research we did based on the data, the closer the interaction in a market, the higher is the likelihood that you feel infringed, and you are also consequently infringing your competitor. Yeah, this is also a phenomena. There are case studies done on this phenomena, focusing on a very narrow market, maybe on 3 or 4 companies, where they looked at also the law cases, and they could find some incidents there for this phenomena. Whereas this is not really the case with the competitors abroad, especially if they are providing goods which are of much lower quality. The third point was
economic gain because of infringement.
This was indeed not covered in the study. We had in the discussion before quite a lot of arguments why it might be good to have these kind of copying activities, because from an economic point of view, if there is not non-rivalry in consumption, then it really makes sense to distribute that. But we were not able to cover this aspect, because this was a study on behalf of the German Ministry for Economic Affairs with a specific focus on the SMEs, and for them this kind of copying activities are certainly not generating some additional kind of economic benefits. This is more than from the consumer perspective. But this is even more difficult to quantify. And there are some studies in the digital area, and we excluded the digital area here. This is not on the, and we also didn't cover copyright because this was from this methodological approach not feasible to cover that. And there certainly these additional economic benefits are very relevant.
Another question?
Thank you very much for the talk. I find it very interesting. I have another question regarding the methodology. In order to assess the infringement on the damages, did you take into account like the number of lawsuits or like the claim that the actor did, or also you took into account the final decision where they decided whether there was an infringement in real life or it was just, or they came into a settlement or because they thought maybe they can have all the evidence they needed. And just the last question is when you took into account the losses of the company, did you also took into account how much they spent on the lawsuit? Because years ago they had a huge amount of money.
We didn't look at the number of the lawsuits and the outcomes. We are currently there's currently a study done where they cover all the patent cases in Mannheim, Düsseldorf, and Munich, which are the most important courts, and we are going to collaborate with these people, linking this issue. But we didn't do that in this study. And finally, we asked them also for the additional kind of legal cost, and this is in the kind of number of additional costs included. But we didn't have a specific case study on the specific cost per lawsuit. This was not feasible in this study.
Just two questions. First, do you have any insights on the amount of revenue that companies typically spend to protect their intellectual property? And second, assuming what we heard this morning that patents are gone, what would be your estimate on the percentage on the copy, or what happened?
Okay, regarding the cost to protect the IPR, we did a study a few years ago where we asked about the number of people in the IPR department. This is kind of one cost component, and one can look at the patent applications and the average cost of these applications. This was not included, and there's currently a little bit of debate at the European level whether one should kind of drive down the cost for patent applications in order to increase just the number, because there are some figures out there that this is 50,000 euros for a European patent application, especially if you cover the whole European Union. But this was not included, but would be an interesting figure. If I remember right, in the study we did a few years ago, on average, I think every company has 0.5% employees working on patents, and then you can make some rough estimation based on that, plus the number of patent applications. But what we have seen, for example, after the economic crisis in 2008, that the number of applications has dropped down, and especially the large applicants have been much more careful in applying for patents, because they say, okay, this is just too expensive, and they focus just on the most important technologies. And we have another PhD working on defensive publication. Defensive publication as a means to kind of state the state of the art in technology, but trying to avoid spending thousands of euros for a patent which you are not using, because you say, okay, I just want to have the freedom to operate, but I'm never going to use the patent because it's out of my product portfolio. And we see a little bit an increase of more attraction for this alternative way to at least not protect your technology, but to protect the freedom to operate in specific technology fields. And here companies are a little bit more sensitive regarding the cost, because the defensive publication is rather cheap compared to going for patents. That means the cost sensitivity is going up, definitely. And the last question, I'm not sure whether patents are gone. And if you see the political economy behind the patent system, I'm not sure whether the forces are so strong to overcome those which are promoting the patent system. And what we see here in this privacy phenomena is that now we face within China a differentiation. There are kind of the good and the bad guys. There are more and more Chinese companies which are trying to compete on the same level with the European companies, and then they are very kind of careful regarding the using of the IPR, and they are also now trying to sue European competitors. Whether this is kind of grounded on the right basis or not, this is another question. But they try to turn around the game, but there are still in China some kind of simple product pirates which are rather kind of unorthodox in using foreign IP. That means we are seeing here differentiation, and we are seeing also a convergence. And therefore, if I look at the 300,000 patent applications in China and the increasing economic and political power of China, I'm not sure whether they are really willing to give up the patent system when they are now really starting to catch up and maybe to pass Europe and US. For example, in the US, the number of patent applications is stagnating or even going down. Japan is going down. Europe overall is not increasing, but China is pushing up. And I mean, there are different kind of political economy games going on, which, from my perspective, are not leading to a patent-free world.
Another question? Thank you very much. I would like to switch over to Mr. Bernd Klein, but before we have to a little technical break, because we have to switch to his notebook on the beamer. So,
Want to grab a coffee?
yes.